Hey everyone, welcome back to the channel. Today we're unpacking the latest and arguably one of the biggest shake-ups to UK immigration in years. If you're watching because you have or want UK permanent residence, indefinite leave to remain, British citizenship, or a work visa, stick around. This video explains what's changing, what it means in practical terms, and what steps you might need to take next. So make sure you subscribe to the channel and turn on the notification bell for upcoming updates. The Home Office has launched a package of reforms that reshape the pathway to settlement and tighten the overall immigration model. The central plank is a move away from automatic, relatively short routes to permanent settlement and towards what the government calls earned settlement. Under the consultation and statements released in November 2025, the qualifying period for permanent settlement is being increased substantially, with the headline proposal doubling the qualifying period for most migrants to 10 years. The new approach aims to prioritise those who make a strong economic or societal contribution and to reduce what the government describes as perverse incentives in the current system. These reforms are being presented as part of a broader effort to rebalance legal migration and curb illegal arrivals. What does earned settlement mean in practice? The broad idea is that permanent status will not be granted automatically after a short qualifying period. Instead, a longer residency period will be combined with demonstrable contributions such as tax payments, sustained employment, family ties, or exceptional personal achievements. The government's consultation suggests discounts for people who are judged to have made a strong contribution, while those who have not will need to wait the full qualifying period. The consultation is open for responses, and the Home Office has signalled an intention to start implementing changes in 2026, should the policy proceed as currently proposed. If you're on a route that previously led to ILR in 5 years, expect that timeline to be extended unless you meet the new earned criteria for faster settlement. Alongside the settlement reforms, the government has published changes to immigration rules and guidance that affect salary thresholds and sponsor responsibilities, which are particularly important for companies and skilled migrants. The skilled worker route has seen step changes to salary thresholds over the past year, and the government updated the immigration salary list and going rates in November 2025. For many new skilled worker applicants, the general salary threshold has increased, meaning employers and applicants should double-check whether their job meets the revised going rate or the higher general threshold. These changes affect not just initial grants, but extensions and sponsors compliance duty. If you or your employer haven't recently reviewed the going rates for your occupation, now is the time. Citizenship is another area where practical realities have shifted. Application fees for naturalisation have been a recurring point of debate, and the Home Office fee tables updated in November 2025 show that charges for nationality services remain a significant cost for applicants. Beyond fees, the proposed settlement reforms could indirectly impact citizenship timing because longer residence requirements for ILR would push back the earliest point at which many people could qualify for naturalisation. In short, anyone planning to apply for citizenship should factor in both the financial cost and the prospect of a longer wait for the underlying immigration status that makes naturalisation possible. It's important to say something about asylum and how the government's broader immigration agenda ties into refugee and protection policy. Recent Home Office statements and coverage in the national press outline a tougher stance on asylum. Proposals include limiting automatic rights to long-term settlement following refugee status, introducing shorter temporary protection periods subject to review, and tightening access to accommodation and benefits for asylum seekers. These are controversial measures that the government argues will deter irregular routes and rebalance public resources. Critics warn they risk creating hardship and instability for vulnerable people. If your interest is in family or humanitarian routes, or you work in law, charity, or local government, expect debates and potential legal challenges as the details are debated. So what does this mean for people currently in the UK or planning to come? First, if you're already on a route that typically leads to ILR, do not assume the 5-year timeline will remain. Start gathering robust documentary evidence of your economic contribution, employment history, tax records, and community engagement now. If the earned model is adopted, having demonstrable proof of sustained contribution will shorten your path. Second, for employers sponsoring international staff, rerun salary checks, and audit sponsor duties, the recent guidance updates require sponsors to ensure roles meet updated paying rates and that compliance is airtight. Third, if you were budgeting for citizenship applications, recheck the exact fees and expected processing requirements, because both the cost and timing landscape have shifted. There are also political and public policy layers to watch. The reforms are part of a high-profile push by the Home Office and the government to show control over migration flows, and opposition parties and NGOs are already airing strong objections. Some political voices have even floated far more radical proposals in recent months, like abolishing ILR entirely or mandating short-term renewable visas for most migrants. Whether any of these more extreme ideas gain traction is uncertain, but they underline the fact that the public debate over immigration policy is intensely active and could produce further changes in the medium term. For migrants and advisors, this means staying informed and ready to respond to consultation windows and propose statements of changes from the Home Office. Practically speaking, here are concrete steps you can take today. Keep meticulous records: payslips, P60s, bank statements, tenancy agreements, council tax bills, and letters from employers and community organisations. Ensure your passport and biometric residence documentation are up to date and that you meet any English language and life in the UK testing requirements if you aim for citizenship. Employers should update contracts and HR systems to reflect new salary thresholds and ensure compliance with sponsor guidance published in November 2025. Legal practitioners and advisors should consider submitting responses to the Home Office consultation if they represent affected clients. Finally, if you're unsure where you stand under the new rules, seek specialist immigration advice, because the changes are both technical and consequential. Let's talk timelines and uncertainty. The Home Office consultation sets out plans and proposes implementation windows that could start in 2026, but consultations can lead to amendments, legal challenges, and parliamentary scrutiny. That means some elements may be delayed, altered, or ruled unlawful. Still, the direction of travel is clear. Longer qualifying periods for permanent settlement for many migrants, more emphasis on measured contribution to British society, and parallel efforts to clamp down on irregular migration and reshape asylum entitlements. Decision-making timelines will depend on legislative and administrative steps, and likely opposition in Parliament and the courts. Keep an eye on official Home Office announcements and the Commons Library briefings for authoritative summaries as things progress. If you're producing content or advising clients, accuracy matters. Quote, "The Home Office statements and cite the specific statement of changes when discussing technical eligibility criteria, because the devil is always in the detail which occupations qualify for lower salary thresholds, what counts as a strong contribution, and how temporary protections are defined will determine real-world outcomes." The House of Commons Library provides useful briefings that summarise proposals and explain parliamentary processes. They're a good go-getter for accessible, trusted background. To wrap up, we're seeing one of the most significant migrations policy shifts in decades. A move to earned settlement, longer routes to ILR for many people, updated salary thresholds for economic routes, and tougher measures in the asylum system. These changes will reshape planning for migrants, employers, and advisors alike. If you're directly affected, start gathering evidence of contribution and check the new salary and fee schedules now. If you're an employer, audit your sponsorship practice. If you're watching from policy, law, or advocacy, expect lively debate and possibly legal challenges as these proposals move through consultations and implementation phases. Thanks for watching. If you found this useful, like and subscribe, and hit the bell so you don't miss updates. I'll try to bring summaries of the consultation responses and the Home Office's next statements of changes as they come out. If you have specific questions about your route or situation, drop them in the comments and I'll address common themes in future videos. Stay informed and see you next time.